And joining us this week in studio for the first time in quite a while, Dr. Roger McEowen, who is an ag law and tax professor at the Washburn School of Law. Good to finally see you close to close here.
Yeah, good to be with you, Ken.
All right, so the issue we're going to talk about is one that I think we could probably talk about every month, and that is, and I guess it's even timely this time of the year. We're spending an awful lot of time working on those fences, maybe building new fences, but just because that old fence is where it is doesn't necessarily mean that is the true property line.
Well, that's true. It might be, but it may not be. And that does create a lot of issues. And I always kind of hesitate talking about this topic publicly because it generates so many questions for me. It's just, I end up digging out for a week after I talk about it because of all the questions that come up. But often in agriculture, we'll buy a farm and there are old fences on it that have been there for decades or even a century. I had a situation come up about 2 months ago where it was a fence that was built in the 1880s and there were still remnants of it there, but it didn't correspond to a survey, and that's what creates the issues in a lot of these situations. So the question is, what controls?
Has it changed over the years? Because, a lot of times we're able to make those transactions with a handshake, talk to the neighbor, everybody was okay, but with all the technology, is that, and maybe as generations change and become more savvy, is that when it becomes, you have to utilize some of those tools?
Well, there's a piece to that that's important, and it goes to the usage issue of the fences. The usage of a fence may have been treated as the partition or the boundary between a couple of properties for a long time. And subsequent owners just continue to treat that existing old fence as the boundary, but then somebody has it surveyed. They use some new technology, GPS, whatever it might be, and lo and behold, that fence is not on the survey legal, so put it in quotes, boundary. So then what do you do? And what a lot of people don't realize in ag is that more often than not, the usage of property, usage of a line, whether that's a fence or whether you and I are adjoining property owners and I farm up to a point and you farm up to a point and we kind of treat that as the line. Usage, more often than a survey, actually defines the legal boundary. And so if that's the case and it's different than what the survey says, we can have corrective deeds filed and establish that old fence as the legal boundary. And a lot of people don't realize that. So really, if you've been, say your family's farmed it for a couple generations and there may be off, it may end up being a few feet that could be several acres, if you come to an agreement, that would meet muster? Yeah, you can come to an agreement and then we can have corrective deeds issued at the courthouse, and that gets the land records changed. We could enter into a memo of understanding between us. We can file that on the land records. Some courts, not so much in Kansas, but other states, kind of an equitable title action can be filed to straighten things out. The disfavored approach is, of course, pacing and dueling at 20 yards. We don't recommend that approach anymore, but that is an approach you look back in history, and that was utilized to settle fence disputes. Sure.
All right. Dr. Roger McEowen, who is a tax professor and is a presenter at the Washburn School of Law, ag law specialist, of course. Stay with us. We'll come back with more in just a moment. And our guest is Dr. Roger McEowen for the Washburn School of Law, and we're talking fence kind of law, fence challenges, and let's talk about now, a lot of folks have small acreages out in the country. Is there a difference between, say, you as a rural landowner, but maybe aren't in active production agriculture? Is there a difference when we look at those type fences?
Well, I think probably the big difference there is if I'm not producing crops or I'm not raising livestock, I may wonder why do I have to contribute toward my neighbor who is a farmer in building or maintaining that fence that's on the boundary line between he and I. It's, he needs the fence to keep his livestock in. I don't need the fence. Well, you kind of do. You need a fence to keep the animals out, but this is a fence in jurisdiction. So that creates confusion. And the rule on that in Kansas is if there are common uses, same uses on both sides of a boundary fence, a partition line, then the one that has the livestock has to bear the cost of fixing that fence. But if the usage is not the same, one party has livestock, the other party has crops, or is a rural landowner that's not raising anything, then that's not common usage. It's not use in common, as the state attorney general has defined that phrase. And each party on both sides of the fence bears an equal responsibility in building and maintaining that fence. And that upsets some people that don't raise livestock. They think, you know, I'm not responsible for it. Well, you are. In the state of Kansas, the rules are pretty favorable to the livestock industry.
So if they come to some sort of an agreement, it would be, in a sense, a dollar for dollar cost share then for that fence, because I would guess that some may want to use hedge posts, they want to use creosote posts, some may want a 3-wire, 4-wire, some may even want just the basics.
Or maybe I've got clear pasture on if we decide to adopt the right-hand rule and I fix what's to my right and you fix what's to your right as we face each other. Maybe I've got clear pasture and I gave you rocks and trees and water to help yourself. I'll fix my half. The statute says equal share of the total cost. So we can come to whatever agreement we can come to. If we can't come to an agreement, then the procedure in Kansas is that we need to call the fence viewers, and that's our county commissioners.
Have we had a lot of this decided by the courts, or typically can it be done by county officials or surveyors, some of those, before we get to in a sense, spending a lot of money trying to defend our position?
Well, there's a lot of juicy court cases involving fence law in Kansas. So, yeah, fences create bad neighbors if there are disputes, and they end up pretty heated disputes, and we end up in court on those. But that's not to say that you can't come to an agreement, and if you do, you can have that recorded on the land records, and it'll bind you and all the successor owners to that tract too. And that's the approach we suggest, but it doesn't always work out that way.
All right, Dr. McEowen, folks, I know you've written about this extensively, so how can folks get more of your past articles and other things to learn more? I know you have a blog.
Yeah, I have a blog. It's accessible through my website, and that's washburnlaw.edu/Walter, W-A-L-T-R. You can access the blog from there. You can also access my articles page on the website, and I have the Kansas Fence Law publication that I keep updated on my articles page. But recent blog articles on this too.
Okay, very good. Well, it's great to see you in person now. Let's look forward to doing this again.
Good. Thank you.
All right, Dr. Roger McEowen from the Washburn School of Law has joined us. Stay with us. We'll have more coming up.